Good afternoon. It is March 2nd. It is the afternoon of the 28th day, almost the end of week 6 of the Alec Murdaugh double homicide trial. Week 6. And all that's left is to charge the jury. That's a fancy way for saying jury instructions. Not every jurisdiction says charge. Some say instruct the jury. Some say charge the jury. Either way, they are giving the jury the law that they will rely on in determining this case. And they will take that law, hopefully, and match it to the facts, hopefully, that have been presented to them, and then come up with a verdict. So they need to be listening to the different, not just the different instructions for the crimes. There are 2 crimes charged here: the murders of Maggie and Paul, each on separate indictments, and then the possession of the weapon that nobody ever talked about, because if you think he did it, obviously there was a gun. So those are the crime instructions, but also the instructions on how to use other parts of the evidence: the 404B, the motive and opportunity, the reliability of witnesses. All of those instructions are important. Jury instructions, or messing up jury instructions, is one of the fastest ways to get a conviction overturned. If something gets messed up in jury instructions, it is a huge problem. So though jury instructions can seem dry and boring, I'm here for this judge reading them. I'm ready. But though jury instructions can seem dry, they are critically important in a case. And the jury gets a copy of those that they can go over when they go back to deliberate. And then we will see how long the jury will get to deliberate today. So once the judge gets back on the bench, we are going to get to jury instructions. Here's the thing. This jury has a very difficult job. This is a hard case. I know it doesn't seem like it's a hard case for some. For me, it is a difficult circumstantial case. It was not presented super clearly. There's a lot of moving pieces. It is 6 weeks. And I hope that the closing arguments help this jury come to a decision one way or another, because this is right in that area where you see the defense arguing for the jurors that are just not going to vote towards guilt. That's what they're doing. But I think if you have 1 or 2 jurors that are leaning towards guilt, the results in this case are, let's do it this way, the things I'll be least surprised by. I will be least surprised by a hung jury, then a guilty verdict, then a not guilty verdict. That's where my level of surprise is, because I think it's going to be harder for them to come back not guilty, because someone on this jury is going to look at Alec Murdaugh and be like, no way. You lied about the time of the murders because you knew when the murders were, because you did it. So no. And I think you could absolutely get jurors that are like, no, the state didn't prove it. I still think this case is a very a difficult one for a jury to come to a unanimous verdict. Doesn't mean they won't. It absolutely doesn't mean that they won't. But it's hard. And I give them, we're going to give them some time and see what happens today. See what happens. See what time they get the case. It's 2:54 in the East. And we'll see how long they deliberate today. So I think some of us are still hung independently. Did the state prove it? Did they not? But the closing arguments kind of inflame the passions. And so you get kind of the feeling, we got almost a preaching kind of a closing, right? And some of the jurors might love that. Some of the jurors might be turned off by that. And we will see. So with that, I'm going to roll the intro. We're going to get ready. I'm going to answer some questions until we get to that. We will hang out here after jury instructions are done, answer questions and talk for a bit and go from there. That's the plan for the rest of today. As I've said before, if you want to sign up at Law Nerd Alert, I will let you know when I'm going to go live. It is my goal. It is my deepest hope and desire that after 6 weeks, we will be live together when this verdict comes down, and I won't break anything. I break things when I get overly kerfuffled. So that is my deepest desire. So if you want to stay in the loop, lawnerdalert.com is a great way to do it. Open internationally. I will not spam you with emails after this trial. During this trial, there's a lot going on, so I will keep you in the loop there. And then, I don't like getting a ton of emails either, so I get it. Let's roll the intro. It's good to see you back, Law Nerds. Jury instructions are important. I know they're not the most fun to watch, but I will talk through the important parts of the jury instructions as much as we can. They're going to get the intro charging instructions. The crime instructions are interesting. And then there are a few others in here. I want to hear how they're worded in South Carolina. So I'm very much looking forward to this. And aren't we ready for Judge Newman to just read us stuff? Who's here just because they want to hear Judge Newman read us stuff? I should put up a poll. Miguelina, let's put up a poll. Jury instruction, we don't care about her. But here's the poll. Are you just here to hear Judge Newman read us stuff, yes or no? Because that's a yes for me.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Yes, some days I just bop out. I still love that music. I really do. I had it created for the podcast. I've used it for everything because I like it so much. So we're gonna leave that poll up for a little bit, and I'm gonna answer some questions while we wait for the court to come back. So let's see. We're just waiting for the court to come back. Let me make sure my audio's on so I can hear it when the court comes back. Normally, you start getting the kind of hot mics before they're coming back in. CBS News reported 3 hours ago that court officials say the jury will deliberate through the weekend. Well, be on the email list. There is no weekend for... My kid has a competition this week. No. Well, here's the thing. The judge will do scheduling with the jury, or the judge will do scheduling with the attorneys at the end of this, and will tell them what the procedure will be for jury deliberation, for how long they will deliberate, and then for when they will come back and how much notice will be given when they come back. So that's what we will do. Let's see. I wanted to see if Avery posted anything about this on Twitter before I go back to questions. Let's see. Avery said, against all odds, I'm writing about O.J. Simpson today. Okay. Wait a second. Why? O.J. Simpson, people keep asking me the opinion of the... What is happening? Do we need to know? Yeah, we need to know. Okay, we just need to know. We need to know. Law nerds, we need to know. What in the world? What in the social media is happening? You guys tagged me in this. I ate over lunch. This is 3 minutes long. Yes. Let's. Because. Okay. I've got volume. I have no idea what this says.
Hey, Twitter world, is me, yours truly. Well, a whole lot of people are asking me what I think about this Alex Murdaugh trial.
I'm uncomfortable.
I don't know why they think I'm an expert on it, but...
Wait, really? I don't know why they think I don't know. You've been through one of the most high-profile murder trials of all time. Had a front row seat for that, sir. So, y'all?
I got to admit, when he took the stand, a guy who's an habitual liar, I did watch.
Of course you did.
When the trial first started, I watched him take the stand, and I thought it was probably a mistake.
Okay. Agreed. Okay.
Because the guy is an admitted liar, and it's hard for me to think he can be on the stand 5, 6, 7, 8 days without lying.
Oh, he definitely
what did he lie
lied on the stand.
But lying and stealing money is a little different than murder.
Yeah.
Are
you an expert in murder? What is happening? I did not have O.J. Simpson weighs in on this trial on my Bingo card. I did not. But we're waiting for closing arguments. Look, man, today we've had jurors removed. We've had Bubba's name vindicated. We've had chickens. We've had like 4 jump scares. We've had eggs. I don't know what's happening anymore. Just here we go. Here the fuck we go. This is maybe the only way this could have gone today. From jurors being removed and eggs to O.J. Simpson, sure.
Realized in watching them testify what he was doing. He was just trying to relate to 1 or 2 of those jurors that he was a good old boy. He was one of them. And I'm not sure he didn't succeed in doing that.
Wait, does O.J. also think it's going to be a hung jury? Is everybody just kind of on the same page with that then?
I am not qualified to really say if the guy did it or he didn't do it.
Wait, but if he did do it, how would you think that he did it? If he did, I have questions.
If a juror missed an hour of testimony, they no longer qualified. I've missed days.
Well, some of the jurors were sleeping.
That I haven't watched this. But from what I've seen, do I think it's more likely that he did it? Yes. But more likely equals reasonable doubt.
Yeah. Shit, I did that.
I think he should be looked at more about the death of his housekeeper.
Sorry.
From what
Hold on.
I know.
He thinks it's more he thinks it's more likely that, I'm sorry, I screwed it up. I was trying to pause and I hit the thing and I don't know what in the world is happening here. Carrie Bose, Emily, did you work the OJ case? No, I did not. I have stories about the OJ case though, but we'll save those for a little bit later.
If the guy did it or he didn't do it. If a juror missed an hour of testimony, they no longer qualified. I've missed days that I haven't watched this.
I feel like I missed days of my life too.
Do I think it's more likely that he did it? Yes. But more likely equals reasonable doubt.
So OJ thinks he did it, but he thinks the state didn't prove it. So not
from what
proven?
I know, I would have to say there's a lot of reasonable doubt there. He's going to go to jail for all the thievery he did, stealing millions of dollars.
Yes.
I think he should be looked at more about the death of his housekeeper a few years ago, where he ended up with over $4 million of the insurance money.
That's been adjudicated. Hold on. Judge is back on this. Judge is back. We'll go back to that in a minute. The judge said, remind me to thank the little girl. I don't know who he's talking about, but we'll go back to OJ in a minute when he says bring
the jury.
Okay, bring the jury. We're going to wait for the jury to come back and hear the rest of this. I'm going to leave the court on in the background, so there will be some overlapping audio.
Hard look at that, but it wouldn't surprise me in the least if this guy beats this case. He's going to go to jail. He's going to go to jail for
what we know that
he stole. I'm curious there because
there's a confession.
I got 9 to 33 years. 33 years because I caught some guys trying to sell my stolen property and I yelled at them. Even they didn't think I should go to jail, and the judge gave me, Jackie Glass gave me 9 to 33 years. So I'm trying to see what this guy is going to get. I was up there with guys who had robbed casinos and robbed banks 2 or 3 times, and they had half the time or a third of the time that I got.
Okay.
So I'm always curious to see what kind of time these guys get
for theft,
stealing millions of dollars. When I caught guys stealing my stolen property, the state of California, after I was convicted, ruled it was my property, and they gave it to me, so I have it now. So how do you go to jail for catching guys who are trying to sell your stolen property? Well,
the jury's present.
Thank you.
I do think this guy more than likely did it.
Members of the jury, you have heard the testimony.
Okay.
Received.
Today's been wild.
And heard the arguments of the state
Today's
and the
unhinged.
defendant. I will now explain to you the law that applies to this case. Under the Constitution and laws of South Carolina,
Today is unhinged.
You are the finders of the facts in this case.
Yes, eggs and
I
OJ.
do
We've
not
had
have
brunch
the
this
right
morning.
to pass upon the facts or to even express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine.
They are the finder of
As
fact.
jurors, then, it is your duty to determine the effect, the value, and the weight of the evidence presented during this trial. As a trial judge, it is my responsibility to preside over the trial of the case, and I have the duty to rule upon or pass upon the admissibility of the evidence offered during the trial. You are to consider
I'm
only the
shook.
testimony which has been presented from this witness stand, along with other exhibits and evidence presented during the trial. Any other evidence or exhibits which have been made a part of the record you may consider, along with any stipulations made by counsel. I have the additional duty to charge you the law applicable to this case. And as the presiding judge, I am the sole judge of the law. It is your duty as jurors to accept and apply the law as I now stated to you, then to deliberate in an effort to reach your verdict. And finally, I charge you in this regard that you should not be concerned with what you think the law ought to be, but what I charge you that the law is. You are also the judges, the sole judges of the credibility, that is, the believability of the witnesses who have testified and of the evidence offered. In considering credibility, you may take into
determine
consideration
The
many
facts
things,
and the credibility.
such as the demeanor or manner of testifying, whether the witness had reason to be biased or prejudiced, and whether the testimony was contradicted on the one hand or supported and corroborated on the other hand. You may believe a small portion of a witness's testimony and disregard the larger, or vice versa. All these things you will consider, bearing in mind that you should give the defendant the benefit of any reasonable doubt.
Reasonable doubt. He'll
It
describe
becomes
it.
your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you of its truth.
Me.
There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by direct evidence or circumstantial evidence. The law makes no distinction between the weight or value to be given either direct evidence or circumstantial evidence.
Direct and circumstantial
However,
are
To
treated
the
the
extent the
same.
state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt.
Do they point
If these
conclusively?
circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt.
And I wish the defense had
This
gone into that
burden rests with
instruction
the
more.
state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two.
Because suspicious,
The rules
is
of
what the
evidence
defense should have
ordinarily
leaned
do not
into.
permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witnesses. An expert witness is a witness who, by education and experience, has become expert in some art, science, profession, or calling, and may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may then disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of any other witness, simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it is not contradicted. In regard
They can
to
disregard an
evidence
expert
of
for
other
any reason.
crimes and evidence of alleged bad acts on other occasions, this evidence is limited to consideration by you as it relates to the motive of the defendant for the offenses charged in this case. This evidence cannot be used for any other purpose. This type of evidence must not be considered in any other fashion. In particular, the South Carolina Rules of Evidence provide that evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show action in conformity therewith. Put another way, evidence of other crimes or bad acts cannot be used to show that the defendant is a bad person and therefore is more likely to have committed the crime for which he is accused.
Easy propensity
You may not
instruction.
consider evidence of other crimes
I like
and
it.
bad acts for this purpose or for any other purpose other than it as it relates to the motive of the defendant. In addition, while you may have heard that other crimes and bad acts of the defendant have resulted in other charges or indictments not before you, the fact that the defendant was arrested, charged, and indicted in these matters is not evidence and cannot be considered by you as evidence of guilt in this case, nor do these indictments create any presumption of guilt. As to any other pending charges, as is the case here, the defendant is presumed innocent until proven guilty beyond a reasonable doubt by the state in a court of law. The function of the jury is to determine whether a defendant is guilty or not guilty, and the consequences of a conviction in this or other pending matters is of no aid in determining whether the defendant committed the offense. You should not consider nor speculate about sentencing consequences for this or any other crime.
Every state, they
as
cannot
those issues
consider
are
sentence.
not before you. The fact that the defendant was arrested, charged, and indicted in this case is not evidence and cannot be considered by you as evidence of guilt. Nor does it create any presumption or inference of guilt. The indictments are simply the formal written instruments which contain the charges made against the defendant. The indictments are the formal documents by which this case is brought into this court. The defendant, Richard Alexander Murdaugh, has pled not guilty to the indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant,
I've never heard
which
that language
remains
before.
with the defendant until it has been stripped from the defendant by
Robe
evidence satisfying you
righteousness.
of that guilt beyond a reasonable doubt.
Very different.
The presumption of
language.
innocence is not a mere legal theory. It's not just a legal phrase. It is a substantial right to which every defendant is entitled, unless you, the jury, are satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt. The state must prove the defendant guilty beyond a reasonable doubt. So what is a reasonable doubt in the law?
I'm wearing my robe of righteousness.
A reasonable doubt is a doubt which makes an honest, reasonable, sincere, and conscientious juror hesitate to act. Proof beyond a reasonable doubt must therefore be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it in the most important of his or her own affairs. Proof beyond the reasonable doubt can also be described as proof that leaves you firmly convinced of the guilt of the defendant. Now, there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of a crime charged, you must then find him guilty. If, on the other hand, you think there's a real possibility that he is not guilty, you must then give him the benefit of the doubt and find him not guilty. The indictments in this case allege 4 separate offenses against the defendant. The indictments are murder of Maggie Murdaugh, murder of Paul Murdaugh, possession of a weapon
murder
during
and
the
Murdaugh
commission
are
of a
hard to say
violent
together a
crime
lot.
involving the murder of Maggie Murdaugh, and possession of a weapon during the commission of a violent crime involving the murder of Paul Murdaugh. Each indictment charges a separate and distinct offense. You must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant, Richard Alexander Murdaugh, is charged with the murder of Margaret Murdaugh and Paul Murdaugh. The state must prove beyond a reasonable doubt that the defendant killed Margaret Murdaugh and Paul Murdaugh
that
with
he
malice
killed them
aforethought.
with malice.
Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under the circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed.
Just
But
that it
malice
exists.
must exist in the
Before.
mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed
It's
and
rarely
inferred,
expressed.
do not mean different kinds of malice, but merely the manner in which malice may be shown to exist.
Sometimes it's expressed, but it's not the most
That is,
common.
either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words
Courtroom got a lot more empty
which
this afternoon.
express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other acts of preparation going to show that the deed was within the mind of the defendant would be expressed malice.
Whoever thought about this have been thinking about it for a long
Malice
time.
may be
Like
inferred
that.
from conduct showing a total disregard for human life. The defendant is also charged with possession of a weapon during the commission of a violent crime.
They have to prove he had the
2
guns.
counts. The state must prove beyond a reasonable doubt that the defendant was in possession of a firearm during the commission of a violent crime. A firearm means any weapon which is designed to, or may readily be converted to expel a projectile.
I
In
think
order to find the
They
defendant
definitely
guilty of
proved
possession
Maggie
of a
and Paul
weapon
were
during the
shot.
commission
That was well proven.
of a violent crime, you must first find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond the reasonable doubt that the weapon furthered, advanced, or helped in the commission of the crime. While the arguments of counsel are a beneficial part of every trial, you should remember
They're not
that
evidence.
the statements made by counsel are not evidence. In presenting their arguments, counsel often have referred to the evidence. However, you should base your verdict on the evidence as you remember it. If there are any conflicts between the recollection of counsel about the evidence
I'll answer this one more.
and your own recollection, you should rely on your own understanding of the evidence. You must decide whether the state has met its burden of proof beyond the reasonable doubts based solely on the evidence presented in this courtroom. As you were instructed at the start of the trial, you're not permitted to conduct any independent research about this case. The facts of the case, the evidence presented in the case, or the people or organizations involved in any way in the case. Do not try to find any information from any source outside the courtroom. however
Like the
reliable
HBO
that source
documentary.
may seem to be.
Like
Do
YouTube.
not look at dictionaries or other reference materials. Search the internet,
The HBO
websites,
documentary.
or blogs, or use any other electronic tools
Reddit,
to
Twitter.
get information
YouTube.
about this case or help you make a decision. You may not use computers, telephones, cell phones, smartphones, tablets, the internet,
You can't
or
yeet
other
your phone.
tools of technology with
No.
communication capabilities
Can't
at
yeet it.
any time during your
See if it
deliberations,
comes up.
except only as provided by the court to review the digital evidence in this case. If your deliberations necessitate an overnight break, you may use these devices as necessary, but you may not use them to communicate with anyone about the case until the case is over. This means that you must not use phone calls, video calls, emails, text messages, instant messages, blogs, chat rooms, websites, or any social media, such as Facebook, Twitter, LinkedIn, YouTube, Reddit, and Discord, to send or receive any information about this case.
The model jury instructions have
This
to be
includes information
updated
about a party,
to include all of
a
that stuff.
witness, an attorney,
A documentary.
court officer, or your fellow jurors. News accounts about the case, research on any topic raised, or even any topics you may think would be helpful in deciding the case, or any testimony presented by any witness you may not investigate. During your deliberations, do not read, listen to, or watch any news reports about this case. This includes anything that may be in the newspapers or on the internet, radio, or television. You must not consider anything you may have read or heard about the case outside of the courtroom, whether before or during the trial. Information on television, radio, internet, or from other sources may be wrong or incomplete. In our judicial system, it is important that you are not influenced by anything or anyone outside of this courtroom. If your deliberations necessitate an overnight break, even though you may use electronic devices as necessary for purposes unrelated to this trial, I must urge you to minimize your use of such devices. Many internet browsers, smartphone apps, and social media services, as well as traditional media like television and radio,
We'll just
will
accidentally say
provide
things.
information and news that you do not seek,
Yep.
with little or no prompting. It is a strong possibility that information about this case may be thrust upon you every time you use an electronic device. You must therefore use these devices only as absolutely necessary.
I
You
like the
must
way South Carolina wrote that
ignore
instruction.
and avoid uninvited information about this case.
Because it really doesn't
No matter
blame
for
the
lady and
jurors.
members of the jury, I am required
It
to
puts
charge
it
you the
on
law as I
the
have
advice
done
or the devices.
through these instructions now I'm being given, to help guide you to a just and lawful verdict. Whether some of these instructions apply will depend upon what you find to be the facts. The fact that I have instructed you on various subjects must not be considered as indicating an opinion of this court as to what you should find to be the facts or what your verdict should be. In conclusion, now you've been chosen and sworn to give the parties a fair and impartial trial. When you have done so, you will have completed your oath, and no one will have a right to criticize your verdict. You must not be swayed or influenced by opinions or expressions of opinion you may have heard outside of the courtroom, but rather should base your verdict solely on the testimony of the sworn witnesses who took the stand, the exhibits received into evidence, and the law which I have stated. You should not be swayed by caprice, passion, prejudice, or improper sympathy for or against anyone.
You must
Remember, you
rely
have no friends to reward
on the facts.
or enemies to punish, and all parties are entitled to a fair
What
and
was
impartial
proven?
trial. It is your duty as jurors to consult with one another and to
really do
deliberate
like their
in an effort to
instructions.
reach an agreement. Each of you must decide this case for yourself, but only after impartial consideration of all of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I stated earlier, you are the judges of the facts. Your verdict must represent the considered judgment of each juror. In other words, your verdict must be unanimous. Now, you may have noticed that I have read these instructions. I do so to give you the law as accurately as possible. I will give you a copy of these instructions to have in the jury room. You may refer to these instructions to assist you in your deliberations. You must consider the instructions as a whole and not follow some and ignore others. And Madam Forelady, it will be your duty to preside over the deliberations of the jury. If during your deliberations you should desire to communicate with the court, please reduce your message or question to writing, signed by your foreperson and the foreperson only. Do not address any questions to anyone other than the court, and reduce it to writing and pass it to the bailiff, signed by the foreperson and the foreperson only. It will then be brought to my attention. I will then respond as promptly as possible, either in writing or by having you return to the courtroom. I caution you, however, with regard to any message or question you might send, that you should never state or specify your numerical division at the time. Now, you've heard the testimony and you have heard the law. Whatever your verdict, Madam Forelady, you will indicate
Go forth.
the verdict on the back of each indictment and then sign and date
interesting.
your verdict.
They sign the indictments, not the verdict
You'll have
form?
these 4 indictments,
Huh.
and on the back of each indictment is a place for verdict.
Interesting.
And each one, as to each one, you write your verdict,
I'll pull up the
either
indictments
not
after this.
guilty or guilty, then sign
'Cause we have
and
them.
date the verdict.
In a lot of jurisdictions,
You're not authorized
They
to
have a
write
jury
the verdict until
verdict form
all of
that's
you
different
have
than the indictment.
agreed
That's real
on the
interesting.
verdict. Now, in just a minute, I will send you to the jury room. But prior to doing so, I want to ensure that from the 12 jurors we have remaining, if there is any reason
One
that
alternate.
any one of you cannot continue deliberating, please let me know at this time. We have 13 jurors. Only 12 can deliberate.
One.
So out of the first 12 jurors now on the panel, if
One
there are any
alternate.
reasons why you cannot continue, please let me know at this time before I excuse the alternate. A show of hands as to anyone who cannot continue deliberating. All jurors then seem to be
Oh, they're in it now.
good shape and good
They've
to go.
been here for 6
So
weeks.
when the jurors,
They want to go talk.
when the jury leaves the courtroom, the alternate will remain. And the alternate is,
The alternate will remain separate from the jury, and the jurors will get to go talk for the
I
first
will
time
send you
about
to
this
the jury
case.
room, all of you, except for the alternate. But do not begin deliberations until you have received a copy of this jury charge, the indictments, and the exhibits. Once you receive these things,
That's interesting.
that will be your signal to begin your deliberations. Once you begin deliberations, you will deliberate until you have reached a verdict, at which time you will knock on the door, advise the bailiff, and we will bring you out to receive your verdict. So if all of you will now go to the jury room,
One of my
except
courthouses
for
had a
the
button,
alternate,
So
juror
they
number 741.
they
who
did like
will
a one
remain
press, two
with us.
press for
All the
verdict or
others go
question,
to the jury
and you could hear it from the courtroom. So it was interesting being in the courtroom to do things and hearing your jury buzz the buzzer versus knocking on a door. So the jury has been charged. The South Carolina jury instructions are very direct, I think. They are very clear, I find. And they are very, very heavy on the burden of proof.
Whatever it is. No,
Don't-
What about it?
Don't excuse the alternate.
Been going for 6 weeks, and if we, could perhaps hold the alternate in the case there's a problem with the 12,
Yes.
and we have to insert the alternate
Yes.
during the deliberations.
Yes.
No, the state concurs with that.
Yes.
First, the statute says alternate must be excused once the jury begins
It does.
deliberating. And that's always a risk that is taken. So with the consent of the parties, if that's what the parties want,
What?
Mr. Murdaugh,
Yes, sir.
do you want me to hold the alternate in the event something happens to any other juror?
Yes, sir.
All right, very good. So, Madam, you will not be dismissed. You will remain as a member of the panel while the jurors are deliberating.
That's such an odd
but will,
statute.
need to be
Huh.
taken someplace separately from the panel to ensure that you do not talk with anyone or communicate with anyone. And we'll figure all that out in a few minutes. But aside
No, I don't-
from that,
Okay, we'll talk about that in a second. That's so odd.
aside from that, if you all will review the exhibits with the court reporter and the bailiff, you can take the charge and the indictments in, and the jury may begin deliberating. Okay, thank you for reminding me on that. Any additions or exceptions to the charge?
Voluntary intoxication, Your Honor?
Yeah,
No.
Voluntary intoxication was not charged, it was not raised. I cited with the fact that it was not raised as a defense.
No.
It would not be appropriate. to
Why in
charge.
the world would you ask that? All right, whatever.
Okay.
The court
Why is
denied
everyone standing?
that instruction because it's like church, Your Honor. They're waiting to be told they may sit.
Clip on it. So, let's see.
It's
is there a
so
separate
odd.
room the alternate can go to for the time
The
being?
alternate. Okay, I'll talk about alternates in another
For the time
jurisdiction.
being.
We'll talk about voluntary intoxication in a
Just for the
moment.
time being.
They need to talk about scheduling, please. Can can we talk scheduling? How close do you want the defense attorneys to be? Everyone's going to stay in the building today. It's 3:30 on the east. What time do they let the jurors deliberate to? How long? So we'll talk about everything that just happened in a second. Oh, they muted us. Okay.
741, if you will follow court officer to a place.
They're going to go put the alternate somewhere safe. And the alternate will have to sit and wait. That's so odd.
Yes, sir.
Your Honor, may I approach with Mr. Waters if something has come up that I think I need to bring to your attention?
Okay, so while they're approaching, we're going to leave that up. Okay, the statute says that the alternate must be excused once the jury is charged. Why I found that odd. There are times when jurors will take ill, when jurors cannot continue to deliberate, when jurors have a death in the family or someone gets sick in their immediate world and they cannot continue deliberating. Here's the problem. If you excuse the jurors, if you excuse the alternates and a juror is unable to complete deliberation, it is a mistrial and the case starts all over. So to have, Creighton just made a whole face. So to have a alternate dismissed when the jury starts deliberating is a strange statute to me. So the attorneys were like, wait, please keep the alternate. This is a 6-week trial. You never know what's going to happen. Often the alternates don't sub in the middle of deliberation, but that's not always the case. It's just an interesting statute. Amy Yo said Florida excuses the alternate before deliberation too. It just, then what do you do? What do you do if a juror can't deliberate? Do you just mistrial it and start over? I don't know. Maybe it's because I practiced in California where like jurors get into car accidents on the way to court and shit. It just, again, strikes me as odd. In Maryland, during my jury duty, the alternate had to be excused during deliberation as well. Criminal case too, obviously not as high profile. That is, it's just an odd, again, differences vary state by state. I just see the practicality for me of keeping the alternate. Generally, they put them in the jury room. So there's a jury room where the jurors come in for the day, depending on the size of the courthouse. Smaller courthouses now. And they put the jurors somewhere where they can't be talked to and keep them separate. And then they put the jury in their jury room to deliberate. Also, generally, jury deliberations in California begin before they get the exhibits. I've had verdicts come back before they've gotten the exhibits back to the courtroom because the exhibits get reviewed and go back. So when jurors go back, they get the jury instructions. In my jurisdiction, they pick a 4-person and then they begin. But whatever is going on up at sidebar, I very much want to know, and I wish they would put it on the record. Something came up that Poot wanted to bring to the court's attention. So they're doing that. Anyway, so the alternate juror is staying and will be there throughout the deliberations. I hope that they talk about the scheduling of how far away the attorneys are while they're waiting for the jury, and if the jury is going to deliberate throughout the weekend. I hope that we hear from, the AG is approaching? Sir? Okay. The boss is also approaching the bench. What else? Voluntary intoxication. The prosecution asked for a voluntary intoxication instruction, and the voluntary intoxication instruction generally says if you are intoxicated when the thing happens, but you chose to get intoxicated. So this comes up a lot in DUI cases. Like you can't say, I didn't have the intent. Well, that's a bad example because DUI doesn't have intent, but I didn't form the intent because I was intoxicated. But if you chose to get intoxicated and then you do the thing, you can have a voluntary intoxication instruction saying it doesn't negate the mens rea of committing the crime. They asked for it. The defense didn't offer a defense about involuntary intoxication, like, he couldn't have formed the intent, because they're saying he didn't do it. So they're not going to argue that he was under the influence of opioids.
You may take them all in along with the...
they're carting in the
This on top.
exhibits. They have got a big old wheelie cart and they're going to load up the exhibits, including the guns, and send. I think he's asking, do you want us to send the guns back too? They're going to cart up all the exhibits and send them back. We would let the jury, we would send the easy exhibits back and then not send physical evidence. And if we had weapons in evidence, we would generally send back
We'll
photographs.
be in recess waiting for the verdict.
Okay. So the prosecution asked for a voluntary intoxication instruction and they were not given. It was not given. And I agree with it not being given. I don't know why they would ask for it. It was not raised in the defense. So I guess they're going to be in recess. I don't know what time they will dismiss the jury for the day. Let's go and see if they'll still show the courtroom. Hopefully they'll switch to the bigger view of the courtroom in just a moment. That would be helpful. They will take the defendant back to lockup within the courthouse and we will wait for today and see what happens. So with that, ladies and gentlemen, we're on verdict watch. It's happening. The jury has been dismissed and we are on verdict watch. So with all of that, we will see what happens. I love getting a peek inside the courtroom and watching all the people do the things. So we're just watching the people do the things in the courtroom. The defendant hasn't left the courtroom yet. It looks like they're trying to clear the gallery out. And I'm going to answer some questions. Let the verdict watch begin. And they did not say what the timing will be on when they will let us know how they have reached a verdict. Hopefully we'll start seeing that being reported by those inside court and the media outlets inside of court. So when will the verdict be out? I don't know. Could be, could be today. Unlikely for me. Could be tomorrow. Could be over the weekend. Could be next week. How long does the jury get to deliberate? As long as they need to. It's like, how long should a good book be? As long as it takes you to tell the story. I've said I've had verdicts come back before they've even gotten the exhibits. I had one jury buzz almost immediately when they went back. It was probably 4 minutes after they went back. They buzzed and said, can we get the verdict forms? Because we were putting together the verdict forms and the jury instructions. They were like, can we get the verdict forms? And we're like, oh shit. So we sent them back. They had a verdict in 10 minutes, under 10 minutes. So they were waiting on the court. They had gone in, voted for a 4-person, taken an initial vote. The initial vote was guilty. And they all went, great, guilty. And so then that came back in a record amount of time for me. So under 10 minutes is fast. Then I've had other jurors that have come back in, half hour, 45 minutes. So you kind of stay close depending on the type of case. This is a 6-week trial. This is not a fast trial. This is not a clear-cut case. I don't think it'll come back that fast. MB, I just got my jury summons for LAX courthouse. My last trial as a juror was downtown LA. I have multiple friends on the bench at the LAX courthouse. I used to work there. There are close places for lunch that are good. The cafeteria, the last I was there, was not great. So bring a lunch, bring a book. The jury room's comfortable though there. And you never know if you'll end up on a district attorney case or a city attorney case. Lots of interesting things. All right. I'm going to answer some questions. If it does come back that fast, does it cause issues? No, it doesn't. The jury takes as long to deliberate as they need. I could see them trying to beat the weekend. I could see them trying to beat the weekend too. Hogue, with a verdict sometime tomorrow. Yeah, I could. I think it would be unlikely to have a verdict today, but we will go through that. What's the quickest verdict ever? I mean, my quickest verdict was 10 minutes. That's pretty damn fast. So how fast are verdicts? It just depends. I'm sure there's somebody else who came back with verdicts in faster time than that, but mine was also a pretty simple cut and dry case. And it also wasn't it wasn't a super violent case. It was a very, very clear-cut case that probably shouldn't have gone to trial, but the defendant had a right to a trial. So he said, let's go to trial. And we're like, okay. And that's a thing. Sometimes you get these really clear-cut cases and the jurors are like, why are we here? Well, because the defendant wanted you to be. Will you send a text alert if we get a verdict? Yes. I will send all the alerts if we get a verdict. I'm going to run through questions, see if the court comes back with any questions, and then go from there. So again, with felony cases, the more serious the case, the longer it can take for a verdict. When you get less serious cases that are more cut and dry, jurors can come back very quickly, especially if the case, some trials take a day, half a day, less. So it is what it is. Aubrey said Law Nerd merch is out for delivery. Much excite. Yay. OG Sean White, EDB, thank you for what you do. You are the best courtcaster I've ever seen. Well, thank you. I like what I do. I will not watch another trial anywhere else. I'm about to become a member. Well, you're welcome. We're going to work on getting some of our own feeds, and then you can choose to watch it either with commentary, without, or both, or one or the other, or what have you. So we will see. I'll go look on the socials. To see if we have any reports from the from those in court about the jury process, but we'll get to that after questions. We're not in a hurry. Question: could the jury come back hung a few times and judge say go back? Yes. The judge will never, I shouldn't say never, absolutes are not a thing in law. I have not seen a court accept a first hung verdict. They will send them back and say try again. Go back and do it again. More. Go back and do it again more. And then if they come back again, they might tell them to go back again. When they're done deliberating, will you send a text? Yes, I'll send a text. I'll send an email. So for those of you not in the text system or that don't want to be in the text system, it is only North America, which is frustrating to all of us. LawNerdAlert.com. You will get an email, and I will go live when we have a verdict. Hopefully a little bit before we have a verdict. Chad, I see you asking about finishing the OJ segment. I will in a minute. I just want to give us a little bit of time. Often jurors have questions right away if something's going on. And so I want to see if anything comes up. I think the closings help the state. I will talk about that. We did talk about whose closing you found most impactful. And you guys were like, Metters. And with, do you just want to have Judge Newman read stuff? 76% said yes, with 19,000 of you voting. So thank you all for that. And with the 40,000 of you still here, go ahead and do the YouTube-y things. I would very much appreciate it. Just as a reminder, this is what I do. So having you be here liking and subscribing and things absolutely helps the channel. Let's see. I'm going to go figure out later who tried to copy claim a portion of the trial. In this case, every single trial it happens. And, you know, we're almost at 705,000 subs. So I would love to get there. That would be great. Jay Birdie Lewis said the part that pushes me over the edge of reasonable doubt is that 3 people went down to the kennels and only 1 came back alive and lied about being there. And that is fair. I think these jury instructions, here's what I'm surprised about as we're talking about these jury instructions. The jury instructions did talk about mere suspicion. And I don't think the defense leaned into that jury instruction enough. He said it once, but that jury instruction is really good. I will go find the jury instructions so that next time we're here, we can talk about them again. But that jury instruction's real good for the defense on these facts in this case. And he did print out one of the jury instructions, and maybe it was on that printout. We didn't see it in court, but I would have wanted Jim Griffin to hammer on that jury instruction more. Look, suspicion is not enough. You think it's sus that he lied is not enough. I get it, but it's not enough. Apparently a juror was let go during lunch. A juror was let go this morning before court resumed. We talked about that in the morning stream. But yes, they're down to one last alternate. And the one last alternate is the one that was napping. So I don't know if I'm the state, maybe I'm just like, nope, dismiss them. This was also the one that was putting, or has been reported to had put Kleenex in their ears a few days ago. I don't know if that's the only alternate left. I might have agreed and said, "Oh yeah, no, that's what the statute says." The statute says let them go, just go. But the state doesn't want to end up in a mistrial either. Do you miss being in court? No, I don't. I love doing this. This is much more fun. So no. We love a WGI weekend. I mean, a juror this morning was expelled. Adam Campbell. Look, the Law Nerds brought the puns nonstop, and I am here for all of it. I appreciate all of the egg puns. The puns are always welcome. There's so many times it can cut both ways in this trial, so it's the jury's task to decide which way it all cuts. It's yes, it is, but the thing is, if it reasonably cuts both ways, that's a not guilty under under all jury instructions. If there's two reasonable explanations, but if the jury finds it not reasonable, then they can yeet that and say we are not considering it. Enrique Cervantes in the chat said, EDB, how do they start deliberations? By voting and discussing? It depends on the jury. Normally the jury, well, no, not normally. In jurisdictions where they have to vote for a four-person, that's the first thing they do is organize themselves. And then the four-person is kind of like, this is how I think we should go through it. Some juries start with taking a straw vote. Where are you at? What do you think? Some say, can we discuss it? Some say, hey, can we start with questions? It really, some say, hey, can we go through those jury instructions again? What's the instruction for murder and how do we decide this thing anyway? It really, really depends on the jurors. In this jurisdiction, they appointed the four-person, so they're not voting on that. And then they have to decide for themselves how they want to conduct their deliberations. They choose. Normally, the four-person will suggest, what do you guys want to do? How do you want to... It's been 6 weeks. Hi. We finally get to talk to each other about this case. What's most important to you? And then they go from there. So that... I think a lot of jurors start with a straw poll. Thank you for being here with us every day. I'm really struggling right now with my host of mental illness, and getting to be here with you every day helps me get by. I'm so glad. I will go check my emails. My team has been kind of pulling my emails for me this trial. At the end of these days, I am exhausted just like y'all are. So I have not been engaging a lot in other information just because my brain is very, very tired at the end of the day. Canadian Pork Chop said, I'm praying for a guilty verdict. Little detective caught his own murderers without knowing it. We will see. I try personally not to get too deeply invested. This jury is going to decide, and I trust them to decide the thing that is right. I trust them to decide what has been proven, and I trust them to decide based on the law. That might not be in accordance with how I see things. And that can be very frustrating. Did you name the pickle? Can it be Bubba related? We have not named the pickle. We'll vote. We'll do pickle names on Verdict Watch at some point. T-Mac, thank you for the gifted memberships. Question, has Randy been seen in court since Alec testified? I don't know. Just let OJ play. It adds to the circus. All right, we will go finish the OJ video. That's where we are. So eggs and OJ are now part of the lexicon. Tiffany Brenner, yes. Yes, they are. Eggs and OJ are part of this case. They are absolutely part of this case. We now have a panoply of brunch in this case. Brunch. Question. The other day you were still hung. Are you still hung? I have not processed today at all. What do I write in the text, Emily? You can just write hi or text me or what have you. It should auto-populate a hello text, but if it doesn't, just hi is fine. Where am I? I don't know. I would want to here's what I'd want to do. I'd want to process today, and I'd want to talk it out with the other jurors, and that's where I'd want to be. Do I still think that this jury can come back hung? Yes, I do. It would be the thing that surprises me the least for this jury to come back hung. But could this jury render a verdict? Absolutely they could. I mean, only they know what they're thinking. Absolutely they could. I would be more surprised with a unanimous verdict than I would with a hung at this point, because I really think there is I really think there is enough for them to find, but enough for them to find guilt. But I also think there are a lot of questions, and some of the jurors are not going to override those questions. They're going to go, no, that's suspicion. And that is suspicion. So I have doubt. So I think you're going to get jurors who think it's not proven. I think you're going to get jurors who think he didn't do it. And I think you're going to get jurors who think absolutely beyond any possible doubt he did it. Who else did it? And that is why it's hard. So let's see what else. We're going to finish this. We're almost done. We have like seconds left. I'm glad we're almost done. So with that, let's finish this real quick.
But once again, more than likely, to me, is tantamount to reasonable doubt. It would work against him in a civil trial, but I don't know if it's going to work against him in this criminal trial.
Your experience
wouldn't surprise me in the least if he beats this.
In a civil trial.
I'm just saying. Take care.
Okay. Well, that's from Avery Wilkes, who said, against all odds, I'm writing about O.J. Simpson today. That's an odd thing. But again, looking at this chat is hung. Let's see what Avery had to say. We are now in recess. Lawyers in the case, including Attorney Wilson, have approached the bench with the jury excuse. I'm not sure what about. Audio has been cut. Yeah, that's so frustrating. Let's see. I didn't see Chanley Painter in court today either. But let's see if there is anything over there or from others. Let's see. Everybody's got their deliberation timer started. I didn't start a deliberation timer. I don't remember exactly what time the jury went out. Let's see. I don't see much reporting. I'll go look for other reporting once I'm done streaming, but I don't see a ton of reporting about that. Let's see. James from court tweeted, so apparently one juror, not blanket tissue, has been causing quite a fuss outside of court and was let go. We didn't see that at all on the record, and they have to put any shifts in the jury on the record. So I didn't see any of that. The juror that was excused this morning. They have to put anything going on with the jury on the record. They have to. So I don't think that that's, I think that if a juror was excused and that's what they're talking about it, that was from this morning, if that makes sense. And that juror wasn't causing quite a fuss. That juror was talking to people about the case, which we heard on the record this morning. So that must be from this morning. It would just have to be. So with that, let us continue answering questions on this case while we wait for a verdict. Amy, you said deliberation started at 3:45, 2:45 Central. Thank you. So 2:45 Central. Poot is trending. Uh-oh. I'll go take a look. Kelly, that's a tremendously generous super chat. Thank you. I appreciate it. Did you ever have a super long, complicated trial and a very quick verdict? I mean, I don't know how to judge super quick. I never thought, I definitely had verdicts that went longer than I had hoped that they would, but I didn't see any of my cases as so complex, because none of them lasted more than a month. For all the trials that I can remember trying, none of them lasted more than a month. So for me, on a month-long trial, a jury coming back in 2 days feels pretty quick, but not coming back in hours. So not super quick, or not unprecedentedly quick. I think once you get to 6 weeks, they're gonna take a couple of days, but you never know. So thank you, Kelly. I very much appreciate that. New subscriber, do you give your opinion when it's done? I don't know if I have an opinion yet. Truly. So Second trial with you. Thanks for cutting law into easy digestible pieces. You absolutely rock. You're welcome, Kara. I'm going to try to get to questions. Lindsay said, I tagged you on Twitter just now. Strange stuff happened at Moselle visit or happening at Moselle visit. Stage short, bike, chicken choy, somebody in the windows. I saw the bike. I saw the pot that said Buster. I didn't see the rest of it, and we watched that yesterday together. So we watched all of the video of the jury view yesterday. Moon Magic Mayhem. Holy hell, this is where we live. Y'all are evicted now. No, I'm kidding. We're on jury watch, so you're not evicted yet. Can the state have brought in an expert to profile Family Annihilator to show how Alec fits it? I would have to look at the law in the state about psychological profiles. Generally, it is considered propensity to say this is a psychological profile. This person fits this psychological profile. Therefore, this person did it. That's propensity. If the defense brings up psychology, then you can rebut it, but the prosecution can't bring it up originally. In that way, that would be propensity. So let's see. Someone said the other day, if the dowel doesn't fit, you must acquit. That's funny. Dowel, they put their rod in a box, didn't they? Got eggs and OJ. Kevin Bacon now on my bingo card. Kevin Bacon needs to be on the bingo card for this trial because at some point it needs to happen. Bingo. Have you watched Scott Cardinal's coverage of OJ? No, I have not. OJ jury was sequestered for 8 months. The state's case was a mess, but they wanted to go home. The state's case in OJ was a mess. They did want to go home. When I worked as a law clerk, before I became a district attorney, we worked in the storage room. I mean, it was massive, but the evidence storage room, and all of the OJ evidence was in that storage room. It was very weird seeing all of the boxes of evidence stacked everywhere in the very dusty, sinus unfriendly, unwindowed cave that I worked in as a law clerk. But some of the offices I worked in as a DA were not much different, piled high with boxes and no windows. I agree with OJ. Interesting. Solo YOLO said, I'm at the Church of John Metters and it's a total vibe. Saving the soul of South Carolina. John Metters definitely wanted to preach that rebuttal, didn't he? Sophie has a motion to go to DEF CON Red because OJ. I mean, if anyone deserves a DEF CON Red, it probably is OJ. Cyrone K said, this case convinces me that we live in a simulation. This case is an odd one, isn't it? It is. Stacks and stacks. There were literally stacks and stacks and stacks of evidence. The jury was not convinced. Also, sequestering this jury now, it's very expensive and states are generally reticent to do it. But in the age of social media, it is very hard to actually sequester a jury from the information. They're not, unless they're very worried about jury safety, like physical safety, like people going to their houses is a reason to sequester a jury. But they still have phones. And so keeping them away from outside information becomes much harder. Will you put up a poll? Guilty, not guilty, hung? No, I don't. I don't do polls on guilt. We're not the jury. But I can put in a poll for how long we think the verdict will take. Let me write that up now. Let's see. What are our options? When do you think the jury will reach a verdict? Oh, wait, that's not the right one. That's the Q&A box. I need the poll box. Wrong box. Put your rod in a box once and everything goes sideways. All right. When will the jury return a verdict? All right, we'll start with this afternoon. Tonight. Friday midday. Let's see, Friday end of day. By Friday end of day. What else? What's the last one? Next week. Early next week. I can't do Never We Live Here Now. Okay. So when will the jury return a verdict? Tonight, Friday midday, by Friday end of day, early next week. There we go. Catherine's asking the real questions. When are you flying? I'm not. You guys are thinking Saturday afternoon. I'm still not 100% sure that they're deliberating over the weekend. I think they probably will. I think they might want to be done before the weekend if they're told about it. Let's see. I just saw chat come in that they are separating the Vallow Daybell trials. I'm not surprised by that. There's been, with the discovery stuff going on, I'm not surprised by that. Maria, I don't know what this trial is yet. I have not decided what we are covering next. There will be a break from trial coverage because I'll need to catch up on all the other cases that I'm covering for a minute. And live trial is a lot of time and energy. Jilly Bear said, at least today we got the answer, the age-old question. Yes, EDB, the eggs do come before the chicken. Case closed. Thank you, Jilly Bear. EDB, how many times can a case go to a jury that cannot make a decision on guilt in the case of a hung jury? Okay, hold on. Let me try to break this down. How many times can a case go to a jury that cannot make a decision? I don't know if you're asking about one jury or multiple juries. And it depends on the state if there's case law and how many times you can retry a case. But that varies by jurisdiction. You can retry cases multiple times. But how many times can the judge send the jury back? If the jury comes out and like, we can't make a decision, the judge is like, go back and try harder. And then they come back and they're like, we can't make a decision, and go back and try harder. Generally, you have to cut it off depending on how much effort the jury is giving it. If the jury goes in, comes out and says, we can't make a decision, and then the judge charges them and sends them back, and they come back 15 minutes later and they're like, we can't make a decision. It's like, try harder, go back and deliberate. If they come back 2 days later and are like, we still are hung, then the judge is less inclined to send them back. So it's very, very, very fact specific for the jurisdiction and the judge. And when it comes to retelling, when it comes to telling or retrying a case after a hung verdict or a hung jury, it really is going to depend on the prosecutorial agency, the case, the state law, the case law in the state. But in theory, they could just keep retrying it unless it's limited by case law or statute. In practicality, that gets very awful. I'm sure there are cases that have been retried 4 or 5 plus times. I just don't know of any off the top of my head. Christina K, I love the way this judge says juror as well. I very much like this judge. He seems like such a sweet man. He does. He is so patient. He is so tremendously patient. Carolyn, thank you so much for the super chat. If it looks like you didn't get to type anything, if you type something, the mods will try to grab it. Sometimes it just goes quickly. Question, can a but-for statement be used to come to a guilty verdict? Only way I could get there. They're allowed to use the circumstances, but the circumstances have to all agree with one another and have to lead them to guilt beyond a reasonable doubt. So when you listen to the circumstantial evidence instruction, it says you have to bring it all together. So no, but for is like, but for this, then that is not reasonable doubt. However, if it's this, but then this, and then this, and then this, and then this, and that's how we know it's him, that is just putting together the circumstantial evidence. Winter Kitten, thank you for the super chat. Poll for number of jury questions. Oh, that's a real hard thing to even put in a poll because you can't parse it. Will you cover the Sarah Boone staircase murder? I don't know. I've not been following it. I would have to look at when it's going to trial. So I don't know. Suggestion for whenever you finally get evicted from the Murdaugh trial, Candace Dillard from Real Housewives of Potomac was just sued for defamation. Really? Oh, well, that would be interesting. You know how we feel about defamation up on this channel. What are the 4 indictments? Oh, let's pull them up and take a look, shall we? Let's do that together. Yay, let's do that together. I said I was going to pull up the indictments. Let's go look. Let's see. Why is my computer being weird? Stop it. Stop being weird. Don't be weird. Don't be weird. Let's see. Where is it? Let me pull. Those are going to take me a second to pull up. So just thank you, chat. Beg the indulgence of the chat. I appreciate it. Take a stretch break. Take a stretch break. I'm going to pull up the indictments real quick. I didn't have them up and ready to go. Stretch break, stretch break, stretch break, stretch break, stretch break. Let's see. Can we pull up the Murdaugh indictments before the music ends while I was stretching? Damn it, probably not. I went too fast. Urgh. I was stretching. Ha! Got him. Crap. I forgot that they're sideways. That annoys me. Okay. We're just going to do it anyway. This is the way they were scanned into the court system. It's annoying as hell. I apologize. Alrighty. Ah, there it is. All right. Witness, SLED agent David Owen, indictment. That's from the 4-person verdict. 4-person of the petite jury, not the grand jury, the petite jury. So this is the grand jury. That's the petite jury. That's where they're going to write guilt or innocence. And then this is where the defendant could plead if the defendant pled guilty. Interesting. They just write it all right on the indictment. Look at that. Court of the General Session, term, charges, indictment for murder. And then they go to the language, but that's where it is up here in this top corner. That's where they write their verdict in. Huh. Look at that. It's right there. And then if somebody's going to plea, the plea goes over there. Well, that keeps everything nice and clean. This is the first indictment, murder, June 7th. Defendant, Margaret Maggie Kennedy Branstetter Murdaugh is what is in the full indictment. The judge did not read it. And then it switches between Margaret Maggie Kennedy Branstetter Murdaugh to Maggie Murdaugh. So the judge was switching between them. It's the languaging in South Carolina is positively delightful. Against the peace and dignity of the state. Wait, you guys are telling me in the chat to click to rotate. I can do that within a PDF? Because I don't think I can. I don't think that's going to happen within this PDF. I tried. It's like, no, ma'am. No, ma'am. No, ma'am. There is no click, click, boom on that. And then it would rotate the entire thing. I only need to rotate part of it. Don't worry. It'll be fine. We're all capable. Look, it says verdict. That's all we need to know. So that's indictment number 1. Indictment number 2, murder, Paul Murdaugh, Paul Terry Murdaugh, to wit a shotgun. Indictment 3 is the possession of the weapon during the murder of Maggie. And indictment 4 is possession of the weapon during the murder of Paul Murdaugh. So those are the 4. If you have Adobe Pro, you can rotate individual pages. I don't have Adobe Pro, but I need it. Clearly, I need it. I need something better than this. Professionals, people, professionals. I organize them all very well within my drive, but I think there's more that can be done. So with that, let me see if there's any other information about the jury's deliberation process. Nope. Let me check Chanley's Twitter and see if there's anything there. Verdict watch. How long do you think it'll take? Let's see. Nope. All right. No mas. Let us go back to questions. What's the longest you've had to wait for a jury verdict to come back? Well, the longest I've had to wait is when they hang. And more than a week. And over a weekend, it feels like an eternity, though. When they go over a weekend and you are worried they're going to hang, it's stressful. There gets to be a point of time in every case where the attorneys that have done the case can feel it, and they can tell that something's going on between the questions the jury's asking, how long it's taking, how long verdicts normally take in their jurisdiction, and attorneys know this better in their own jurisdiction, right? How long do attorneys in this particular courthouse on this type of case normally take? This case is an anomaly. I think it's one of the longest cases in the history of the state. So it's an anomaly. It's fair to think that the jury could take a while. There's a lot for them to cover, and it's very circumstantial. So the chat's asking again, does a hung jury allow for a retrial? Yes, at the discretion of the discretion of the state. Mama Llama said, will the jury be sequestered? No. We've seen nothing about this jury being sequestered. I don't think they will be. I heard some of Buster's jail calls to Alec. I feel less sorry for him now. Sounded arrogant and protective of his dad. Buster does seem protective of his dad. I agree with that. The jail calls are interesting. Those are available on the internet. They're public. Fitz News has made them public. They've been on some episodes of the Murdaugh Murders podcast. So let's continue. What was Creighton trying to add? A new charge? Oh, Lauren R. No. Creighton was asking for an additional jury instruction, a jury instruction on voluntary intoxication. We talked about that a bit earlier. So not a new charge. He was trying to add a new jury instruction. Control and shift. It just didn't let me do it. I'll practice later, I promise. We learned all how to control F ourselves. I will learn how to control plus myself as well. Lizzie said, question, where can I find the still photos taken yesterday at Moselle? I don't know where they posted them. I have not seen them. Let's see if we can find them together. Let's experiment together. We're on jury watch and I have a little bit of time before I have to go get ready for other things. I don't know what time they'll excuse the jury tonight is the problem. Let's see if they're on the Post and Courier. They should be there because the Post and Courier is the official still photographer of the trial. So they should be on the Post and Courier's website. Let me see if I can find them. Jury deliberations begin. Fine. Let's see. Oh my goodness. The shirts that are being advertised on this website are Robeck shirts. I don't even know what that is, but they're stripy and they look golf related. I don't know what I've been listening to on the internet. Either that or it's my husband's fault. Sir, have you been searching golf shirts? Let's see. Photos from day 28. Isn't that today? Today's day 28. Are those today's photos? No, those were 21 hours ago. Those can't be today's photos. Let's see if they're here. All right. These are probably yesterday's photos. No, these are today's. Jim Griffin walks away after giving closing statement Thursday, March 2nd. So these are already uploaded from earlier today, which is interesting. Jim Griffin has been just killing that pen. Line outside of court. Prayer circle outside of court. Let's see. Alec coming to court. Attorneys in court. Alex smiling in court. In the middle of his attorneys. Which is different. He wasn't in the middle of his attorneys. He wasn't in the middle of attorneys after Jim's closing. He was at the end of the table away from the jury. Exhibits shown by Jim. Closing arguments. The judge. That's a great photo of the judge with the seal of the state behind him. That's in the locality. I'll go see if there's photos from yesterday because they're not going to be in this group. All right. Let's go see if there's photos from yesterday. Because that said it was posted 21 hours ago, which is so confusing to me. Here we go. Jury visits crime scene before closing. Let's see. All right. The dog kennel at the Murdaugh Moselle property. This is the up in the corner near where the door to the feed room is. You can see the videographer in the doorway of the feed room. You could get a sense for how tall the videographer is in that. Zoom this a little bit. See if it'll just let me. Nope, it will not. No. Let me do it. Evidence shown in the trial. So this is an overhead that they used in the trial. The trees have definitely grown since the date of the crime, just from what we saw in that video that we watched yesterday. Hopefully we'll get more of the crime scene photos. That's an overview. This is in court. Okay. Those are in court. No. Ruh. Where are the rest of our crime scene photos? I was so optimistic. Okay. So optimistic. Y'all said it's in the upper corner. Let's try that. This is the wrong. Where do we go? No. What happened to the Post and Courier? How did I get onto another site? Let's see. Let's go back to the home page, shall we? And just start over. My brain has literally stopped processing information. There it is. Look at Moselle. Good. Brain tired. Brain very tired. Thank you, chat. This is inside the feed room. This is the drive. This is near the feed rooms. This is the, yes, I can see it's with a tilt shift lens. Photo made with a tilt shift lens. But if you're doing photos of the crime scene, why tilt shift it? Because it blurs like the linear tilt shift. I don't understand why we're using the linear tilt shift nonstop, but okay. They are more artistic, but that is not necessarily what we need. With this, that is the area where Rogan Gibson lived. It was like a multi-bedroom cabin near the road that they never searched. Not ever once. The mailbox, this is the entrance near the kennels. You can see the hangar in the background. The mailbox was at that entrance. No trespassing signs. People being brought in. Sled. This is the procession of coming in or procession of going out. Several vehicles leave the property. Eeks. I don't know what happened. Me. Obviously, user error. The dog kennels and the hangar. The hangar looking back out over Moselle. The hangar looking towards the dog kennels. I like that they note that it's made with tilt shift. Maggie was near the dog house facing the kennels. That is the property that I think they described it more as like a she shed or a gardening shed. That is the dog house facing the kennels with the door open to the feed room. You can kind of see the quail. You can kind of see the quail pen back in there. Feed room. Bullet holes still on the glass? No. Yes. Bullet holes are seen in the glass at the Murdaugh Moselle property on Wednesday, March 1st, 2023. So bullet holes still on the glass. And bullet damage still on the back of the feed room. Small holes are seen on the back of the feed room at the Murdaugh Moselle property. This is the back of the kennels, the inside of the kennels. There's still blankets in some of the kennels. The kennels facing kind of facing the other shed. A chicken. I think that's a toy, obviously a toy chicken. I honestly don't know if the stuffed chicken truly is staged or if the stuffed chicken was just laid there. I don't know if it was just laid there or not. It might have been just set there because that's what happened when everybody left this property, because they never went back to live there. That's the quail pen. The hole in the side of the quail pen. This is the feed room facing out, and you can see the videographer out at the quail pen. Let's see. Emily D. Baker, we use fake hens for broody mamas. Okay. Combined with other things, I think it was intentional. It's a chicken dog toy at Bubba's because Bubba has a chicken. You guys think it was staged? Okay. I don't know. It's a guinea. It's a dog. It's a dog toy. It's a dog toy. So this is from inside of the feed room looking out. Bullet hole looking out. Court TV photojournalist Steve Gresham and Wall Street Journal reporter Valerie Bauer-Ellen stand where Maggie and Paul Murdaugh's bodies were found, around 12 steps from each other. That's a helpful visual. I don't know. Does that help y'all? That's a helpful visual for me. So you tell me what you think. A hose at the dog kennels, the Murdaugh property. So the hose wrapped up. The hanger, the kennels. This is the drive back to Moselle. Let's see what happens. This is the bike, the steps, the house. These are the steps where Gloria Satterfield fell. For those of you that had wondered if it was inside the house, outside the house, it was outside the house. If the bike was left there for 18 months, it would have rust and flat tires. It had rust on the handles. I couldn't tell about the flat tires from the video because of how high the grass was. Oh, nope, those aren't flat. The handles are rusted, but the kickstand's not, and the tires are not flat. So that, I don't know if that helps. That is the Buster Murdaugh pot. Also, the bike wasn't there when the real estate photos were taken. This is the door up to the gun room, but I don't see a keypad on it either. Like, at all. John Marvin said there was a keypad on the door. Maybe on the door from the inside of the house and not the outside of the house. Oh, the shirt. These are shirts hanging in the window. So clothes hanging in the window. I don't know if that's the laundry room. That's not weird to me that there's clothes hanging there, but also in the gun room. If you look at the videos from law enforcement in the gun room, there in that video, there are clothes near the windows. I don't think that's staged. Y'all might disagree with me, but we're going to go back to the Captain America video. And I don't know why the property's not out of the house yet, because the house is in escrow. Somebody's got to take the property out of it at some point. I'm going to go back to the Captain America video and show you what I'm thinking. Because in the Captain America video, there are clothes hanging near the back of the gun room, and we don't have any framing for where and what window that's in. If it's this window by the tree, which is hard to get a sense of because it's just a window, but if it's that window by the tree, again, not zoomed out so you can't tell exactly what window it is. In the gun room, there was a whole rack of clothes. And here, let me see. I'll go pull it up, because in the gun room there was an entire rack of clothes that we talked about when the law enforcement video was made with Captain America ages ago. There was the treadmill was moved back to the back of the room, or the elliptical was moved back to the back of the room, and and there was a whole clothing rack back to the back of the room. Let me go grab it. I know that here. Near the window. So these were Worley's photos of the gun room. Now, in this photo, the windows are pulled, but there was an entire clothing rack there. So I just think this is the clothing rack we're now seeing from the outside because the blinds are up. I don't think that's staged. There's shirts and clothes all on this clothing rack by the window near the gun room. I don't know why the clothes haven't been removed from the house. Ash Axum said, didn't Blanca and her husband live there as caretakers for a while? They did. They did. So, but this is near a window. So if it's if that's the same window, it looks the same to me. That's the window that we're seeing clothes in. And that's a clothing rack from the crime scene photos. I just think they're the same. I do. So that's what I think. These clothes were all in the gun room, and we saw them in the Captain America video, and we saw them in others. So I know people want to think the worst of the Murdaughs. There's a lot to think ill of the Murdaugh family for. I just don't think this is it. The windows might have been open to let air in the house or to let light in the house when people were walking through, but these are the crime scene photos. Why it hasn't been cleaned out yet, I don't know. But it looks like the exact same thing to me. And it looks like a rack of clothes, not one pair of clothes. It looks like you've got long sleeve shirts behind shorter sleeve shirts in the front there. And this looks like a shorter sleeve shirt and then long sleeve shirts behind it. So that's what I'm thinking. That's what it looks like to me. So I don't think that is as big of a deal as it might have seemed. I didn't see the bike and the Buster planter in the other things at all. But I don't know why they haven't removed the things out of the house. So that's that. The Koozie Rob said, question, Emily, your content, love your content, watch since Steffi heard. Would you be willing to do a reading of the transcript of one of your trials? I don't even have the transcripts of any of my trials. I have like parts of transcripts, I think. But I don't have transcripts of my trials. No, I don't have transcripts of any of my trials. And we never paid for transcripts. If a case went up on appeal, there would be transcripts. Very few cases that I did went up on appeal, and most of them weren't even to the transcript stage when they were denied on appeal. So, motion to add sketchbooks to all live streams going forward. Stretch breaks. Sorry to all. We're going to do sketchbooks too, but stretch breaks, yes. How far into trial can you go before you cannot have a plea deal? Could they get a plea deal while the jury is deliberating? They're not going to, but if in theory, it's possible. There's no rule with that. So no rule with that. I see some of you saying the defense is giving a press conference. That would be odd. The jury's deliberating, but I will go look real quick. Okay. I hear you. I will go look. The local news does not have it. Let's go see if Court TV does. Give me 1 second. I am looking on YouTube, but let's see. I do not see that on any of the outlets. And I see some of you saying it's on James. If it's on James's channel, I'm going to let it be on James's channel so y'all can go watch it on James's channel. I don't want to snipe his stream. That's rude. That would be very rude. So I will point you there if that's where it is. I don't see it on, I don't see a formal press conference. So that. So thank you guys for letting me know. And if James is doing it, I will go watch James's coverage of it for sure, but I'm not going to snipe his stream. But you guys can go watch it if you want to go watch it. Will you cover Idaho for trial? Yes. I started covering the Idaho case. I will continue covering the Idaho case. Keypad wouldn't be on the doorknob removed when locks were changed. It wouldn't have been on the doorknob, but normally the keypads are right above them. So normally they're like right there. Let's see. Avery has a pic there in the media center. Well, we were just looking at crime scene photos and debunking the staging of the shirts. So let me go take a look. I wish the state would have been more sympathetic to the victims. Everything is about Alec. Don't most cases focus on the victims? No, they don't. Most focus on the defendant because the defendant's the one they have to prove guilty. So most focus on the defendant. Not an official press conference. They just went into wherever the media holding pin was to have a chat. Okay. I'm sure we'll see. Keypad is on near the doorknob. I didn't see a keypad. The video I tagged you in on Twitter shows someone in the upstairs windows peeking out of the shades. I'll go look. John Marvin's taking care of the property. I will look for that on Twitter. Need yodeling pickle to begin the healing process. We'll get there. At some point, we'll do a cleansing pickle yodel together before I wrap for the day. But my notifications are also just wild. Riley Benson said Dick Harpootlian and Jim Griffin are mingling with the press in the Wildlife Center currently. That's funny. Let's see. There are a lot. I will go through I will go and look for things on Twitter later because I don't want you to sit here with me going, as I, Roadbacks equals Peter Targo's phone are definitely not listening. Phones are definitely not listening. That's funny. I didn't know that. YouTube is listening. Emily, will you please turn on your mic, Elaine merchandise? Maybe. Did I see a Rebel Alliance tattoo on one of your arms? We are twinning, or am I just a major Star Wars nerd? No, it's part Rebel Alliance, part Jedi. It's a half and half on the arm. It's hard to see on this arm, depending on how you twist. It's hard in my camera for me to do this well. I don't. But yes, it's part and part. Thank you for the super chats. He used two guns to make it look like two shooters. That's exactly what was argued by the prosecution, isn't it? I'm home and bedbound. Verlin, thank you for joining our amazing community. We are here. Question from Aaron loves Vikings. Don't we all love Vikings? Why was everything focused on Alec? Oh, we did that. No, the state doesn't always focus on the victims. Yes, some, but there's a balance. Let's talk about that actually for a minute. Let's talk about that balance before I have to kind of finish our questions and wrap. Let's talk about the balance of that. You heard the jury instruction about sympathies, and you can't lean too far in. Juries can't lean too far into sympathies. So for the state, there is a balance between leaning into what the victims have gone through and what the defendant is accused of. And talking about the victims is a balance with proving the defendant guilty. So there's a balance to it, for sure. I hope the alternate has a good book. I mean, yep. Or a hands-on project. I saw lots of crafting in court, knitting, things like that. I wonder if they'd allow that in court anymore because needles. They might not in a high-profile case. They didn't inspect the cabin by the road. Perfect staging area for a surprise attack. They didn't at all. They didn't check it to hide things. And then today they argued he must have been doing it while he was at his mom's house. Question, what do you think happened to the other dogs? I just really want to know. I really want to know too. I don't know if Buster has them. I don't know if other family friends have them. If John Marvin has them. If Rogan Gibson has them. I don't know. But I do know I need to get a different stand for the microphone or for the camera because when I start doing this, my camera starts shaking. I need to rearrange where my mic goes over the weekend. Ever heard of Bill Mitchell versus the Twin Galaxies? No, I have not. Absolutely a cluster of characters in this trial. You can't make this stuff up that happens in court, which is why I'm so fascinated with court. It's just much more fun to be an observer on this side. House sale was frozen as there are questions around it because it was sold and listed before and sold before listed and it's got a lien on it. Interesting. That might be why it's not cleaned out. Picture 43 of 70 shows the door and window with shirts, same window and clothing rack against the inside of the room view. Yes, I think so. The bike would still be, the bike would still be standing after all this time. The planter looked new to me. I hadn't seen the planter before either. Although unlikely, could the jury find guilty on one and not the other? In theory, they could. It would be very strange if they did. But in theory, yes, the jury can do whatever. It'd just be a very strange result. What if they think he murdered but can't prove the guns? I don't think they can come to that result. I don't know how you get to he murdered them. They were both clearly shot. He murdered them, but he didn't use guns to do it. Well, if you don't think he used guns to do it, then you don't think he did it. Either he pulled the trigger or he didn't. So that. Flowers versus MX. 6 between 1996 and 2010. 5 mistrials. Gingy Probs is like, I've got you. 5 mistrials, convicted in 2010. SCOTUS granted cert in 2018, overturned on Batson error. MS finally dropped the charges. State can certainly try and try again. Yes, they can. Retrial, 6 retrials. I'll have to go take a look. But Batson error is not on the retrials. So I'll have to go take a look. But yes, the state can try again. They can. Question, was there any talk about Alec Murdaugh's shooter wearing any protective gear? No, none. No evidence of that, and the jury can't really consider it. There's no evidence of that. I'm going to do just a few more questions. I have something I have to record in a little bit. I'm going to be monitoring for a verdict tonight, and I will just ask you all, if you want to stay in the loop, lawnerdalert.com is where to go. I will email you if we go back live tonight. I'm going to be staying close. I just wonder if the defense closing pushed more people towards guilt than not, because that's what I saw in the chat. When will the jury return a verdict with 17,000 votes? By the end of the day, Friday, 41%. Early next week, 38%. Friday, midday, 13. Tonight, 6. So y'all are thinking they're going to take their time chatting too. I think so too. Frankie's mom said perhaps an argument started at dinner and MM was only there 13 minutes before she saw Paul went to the kennels, perhaps grabbed the belt loop to take back the pills out of Paul's pocket. Could be, but they didn't argue it quite like that. But the jury gets to decide the facts. Question, where does Murdaugh wait during deliberation? In the holding cell in the holding cell in the courthouse. Courthouses have, because they deal with criminal cases, they have a lockup within the courthouse. Where that lockup is within the courthouse, I don't know. Word is the juror this morning was sympathetic to Alec and Poot was unhappy about the dismissal. That may be, but it seems like there was a pretty clear record that the juror had violated their oath and had talked about the case. That seemed pretty uncontroverted on the record. Curious Blue Dog. Until a few weeks ago, North Carolina required that the alternates be excused once deliberations began. Attorneys could go talk to them while jurors were deliberating. Wow. That's interesting. The chat's like, Emily, we live here now. I don't know what happened. I listened to Medder's closing argument. It happened. It happened. Look, I moved to the South. Things happen. That was just the words coming out wrong, but I'm here for it. Deanna said, my husband was an alternate in a murder trial in Georgia, and he was put in a separate room until verdict. That's what they do in the jurisdictions I've practiced in. But you never know, especially with a case this long. Thank you, Amy. That's true. Deliberations don't always last for days in civil cases. Can an alternate crochet while they wait? It depends on the court rules on things like crochet and knitting needles and stuff like that. But generally, people bring books because you can't really be on your phone. I'd be like, I swear I'm not on my phone. I just need to play. I just need to play Two Dots and Love and Pies. Leave me be. Question, and then Pokemon. Question, how long does a Law Nerd Alert welcome email generally take? It shouldn't take too long. Make sure you look for no reply at emilydbaker.com and find it, and then just go ahead and white label it. So if you have Gmail, it doesn't go to spam or promotion. I saw a question. Celeste said, EDB, I would love to hear you explain what you do on career day for your kiddos' school. I've never done a career day. I speak at schools. I've not spoke at my kids' schools while they're there. Barbie asked, are you under tornado watch? Not yet, but that is an evolving situation. Better with the Irish. Those instructions are concise and very easy to understand. They are. I like them a lot. I like those instructions. I like the South Carolina instructions. Look, they have a robe. I wrote it down. because my brain has stopped. Where is it? The robe of, darn it. My robe of righteousness. They equated the presumption of innocence to a robe of righteousness. I want a robe of righteousness. This is my Sith Lord robe today. But I want a robe of righteousness. I love the language. I'm going to find these jury instructions first. Step 1, find jury instructions. Step 2, send to friends in California. Step 3, lobby for new jury instructions that say robe of righteousness. My in-ears are not letting me be great. Look, in-ears. You have to just sit up there. You're wrecking my robe of righteousness. I'm ready for it. The robe of righteousness. It's just. Donna, we have moved from the light to the heavy. I knew someone years ago who unalived his 105-year-old grandmother in her sleep. I'm sorry. This is part of why they wanted to talk about the voluntary intoxication, just in case the jury thought maybe it was related to the narcotics. He's saying he's taking so much. So that, I think, is why they wanted a voluntary intoxication instruction. It just doesn't fit in this case. And the defense didn't argue it. You must not bring in any more eggs. I would be here for it. If a juror was like, hey, I've got chickens, they bring eggs. Do you want eggs? Yes. If found not guilty, can Maggie's family sue civilly? Maggie's family can sue civilly regardless of the criminal outcome. Whether they will or not is yet to be seen. I don't know what they would get. I don't know if there's anything left. But Maggie's, I think Buster is in charge of Maggie's estate. I don't know if it would just put their family through more pain. I really don't. If he's found not guilty on murders and later discovered with evidence that he actually paid someone to commit the murders, can they go to trial for that? There is a lot of research attorney in me that needs case law to answer this question. Here's why. And if any of the lawyers are left still in the chat, I would love you to weigh in as well on double jeopardy. But here's how I see it without doing any research on the case law in South Carolina. Hiring someone to murder them is a separate crime than murder. But the underlying crime is still murder. And you cannot twice be put in jeopardy for murder. And so with the underlying crime, I would also need to look at the exact statute of the law for murder for hire. But the underlying thing is murder. And you can't be put twice in jeopardy for the same thing. And the end thing is murder. Which is why conspiracy is different. Conspiracy is the agreement, and the crime is agreeing, not doing the thing. So could you be charged with conspiracy? In theory, yes. But I think it would be a shit show after this trial. But in theory, yes. Because that's an agreement. But murder for hire is generally predicated on hiring someone to do the thing. But the thing is also murder. So I would need to look at the statute to see if the hiring is the crime, or if the murder is the crime, or if the completed murder and the hiring together. It would depend on how that's written. But I think it would be kind of a mess. So double jeopardy is a thing. You cannot twice be held in jeopardy for the same crime. So that. Janelle Jones said, EDB, my law nerds alerts have been very delayed. Yesterday's came in after 8 p.m. I will go look at what's going on with that after I wrap. If there's a hung jury, does the state need to present their case the same way they did? No, they don't. Casey, it's a great question. It hasn't been asked. No, they don't. They can decide how to present their case, call witnesses, call different witnesses, include witnesses, exclude witnesses, as long as the court allows it. No, it does not need to be presented the same way. And in fact, I have done that in a case, a murder trial that I did. When we retried it, we excluded a witness and went a different way. And that was more successful. Audrey, question. Have you seen the photos and suggestions on Twitter that certain items were staged? That started the whole rabbit hole that we went down. I think we answered the rabbit hole. So with all of that, law nerds, I have got to go. I have a recording that I have to do for, I don't remember for who, for something that's coming out tomorrow. Dateline, maybe. Impact, I don't remember. I have to go record for news things. I will be back if there is a verdict tonight. If not, I will be on Verdict Watch with you tomorrow. I will decide when we will stream. If there are any updates, I will send them to you if the jury asks a question and I don't stream for it. But if we hear that we are getting a verdict, I will go live. I do not care when it is. I will be keeping an eye on that. Medicated moment. Do you think appeal possibility if found guilty? Oh, if he is found guilty, an appeal is a certainty. And in some cases, I'm like, I'm not sure what they'll appeal. In this one, they're going to appeal the 404. They're going to appeal some of the things said in closing, probably. They're going to appeal, what else do I think they will appeal? There were a number of things that were denied, particularly in that 404 realm. The roadside incident, the financial crimes, the amount that was let in, all of that is very fertile grounds for an appeal. And those are the types of things that if an appeal court is going to upend a conviction, those are the types of things they will upend a conviction. Most of the time it's a very high bar to show that the judge somehow abused their discretion. But in the realm of letting in other bad acts, that is really the grounds where you see cases overturned more than any other types of arguments. So, I saw the follow-up question, but was it reversible error? We are not even close to that for me to answer that yet. Not even close for me to answer that yet. That is way too many hypotheticals. So too many hypotheticals. Y'all are saying Brian Enton says that they can deliberate till 10 p.m. Well, I guess we're on Verdict Watch till 10 p.m. I might just pour a glass of whiskey anyway. Is the judge going to come back in? Can you imagine Judge Newman at 10 p.m. being like, and we're adjourned for the day. Let's see. The court says the Murdaugh jury can deliberate until 10 p.m. No plans to order dinner for the jurors at this point. They do have coffee and snackies. He didn't say that. He said snacks. The jurors are not sequestered, so if they want to stop for today, they would go home and come back tomorrow morning. There we go. I will keep you posted. Go sign up for lawnerdalert.com. Lawnerds, thank you for being here. Thank you for being the greatest community on the internet. I always enjoy our conversations. Unfortunately, I have to go. I will be back, maybe, but I will be ready in case it is. I guess we're not going to sleep till after this jury goes home, and I will keep you posted on Law Nerd Alert, on Patreon, here on the channel, on the text crew, on Instagram and Twitter. I will be pushing to MySpaces first and Instagram and Twitter second because I forget about them. And I want to make sure I hit our member spaces, the community tab on YouTube, and all the rest of it. So with that, you guys are saying, OJ story before you go. I mean, we did training. It is a brief story. You're right. I can't leave you with an open loop. You're exactly right. We won't leave you with an open loop, Law Nerds. That's rude of me to do. I forgot. Squirrel. First, when I was a law clerk, we worked in the stacks of evidence in the evidence room, which was kind of eerie after watching the OJ trial in high school. But we did training with the attorneys, not Marcia Clark, the others, with the attorneys from the OJ case. It was, a day and a half, 2 days, it felt like. But time is a construct. So my memory of years and years and years ago and how long things take is not reliable. We did an extensive training, that's more fair, on what it was like for the prosecutors in the OJ case. Storytelling, witnesses, threats on their life, the security they had on their kids at school, what it was like having the bosses at the DA's office involved day by day with TV coverage, and what it was like doing a case with TV coverage. It's actually something that stays with me because I remember how much it impacted that prosecution from the prosecutor's perspective, with the bosses watching the coverage and trying to shift the case mid-case, and how difficult that was for the attorneys involved. How hard it was for them to be picked apart on TV. And I don't know what that experience was like for the defense team. personally, we didn't hear from them. But for the prosecution team, how difficult it was for a case like that. It was really one of the first cases that was so broadly televised with so much media coverage. It changed media coverage of cases, and it impacted the prosecution and how they perceived the case, and it impacted the safety of the attorneys involved, their concern for the jury. It was different. And so wanting to be mindful of that is part of my coverage here. Wanting to be mindful of not impacting the attorneys in a negative way because of coverage. I will be critical of the things that we see, but also I realize that attorneys in cases like this are now getting emails constantly. We see the court getting emails, and that's very, very difficult. That there is a nonstop kind of feed of information, and that's a difficult thing. So I try to be, I can't say I always am. I try to be very conscientious of that. And I see questions like, Emily, you should email them and tell them to do this. I'm like, I will not interfere. I do not want to interfere. I do not want to become a part of the story. I want to break down the court process for y'all. I want to help you understand what we're watching in court and then give you my thoughts and opinion on whether or not I like the style of argument, the different styles of argument, why attorneys might be doing things that they do, what the objections are, if there are objections ever, and on and on. So that's where I try to make sure that my coverage is responsible, or at least I hope that it is. And I hope that it's always mindful of the parties involved, and encouraging people not to contact the attorneys. It's different if you're, Morgan Tremaine or Morgan Knight, and you're like, I actually am a percipient witness to this thing. That's different. If you're the person who's like, serving coffee in the morning and somebody comes in and is like, I'm on this jury, can you believe this? That's different. But for us as the general public to be involved is not what we want to do. So I see you in the chat saying the jury has asked for a monitor. They should have a computer where they can watch things. Maybe it's not big enough. They're going to want to watch things back. I wonder if they want to watch Alex. What are they going to watch back? What do they have on video? Mostly Alex's interaction with police. So I'm sure they're going to go through the evidence and watch those things back. Wouldn't you? Where you can have a chat. So question, Emily, are you working on forming a contract for having your own court feeds? We are working on getting our own court feeds. So with that, I hope that it's helpful. I don't want to be involved. I just want to talk about it with y'all. Truly, I just want to talk about it with y'all. I don't want to be part of the story. It is not my story. These are the stories of the lawyer in court and the cases that they are doing. We get to observe it and discuss it, much like we would get to observe and discuss any other case. So that is always the goal here. With that, y'all, it's time to go. I appreciate you. Law Nerds, you are the best. That is kind of my take. But yes, we definitely talked as LA County DAs about the OJ case, even years after the OJ case, which is somebody who grew up watching the OJ case. Fascinating for me. So I was like, oh, this is what we're doing in training right now? Okay, last question. I saw, Paulie, I saw it before Nightbot grabbed it. If there's a hung jury, does he get bail? There would have to be bail motions, and he still might not. The bail still might be $7+ million on all the financial crimes. So it's not a given that he gets out of custody. I think it's more likely, even if this jury hangs, he stays in custody on the financial crimes. And with that, Law Nerds, maybe we'll be here later. Maybe we won't. I'll keep you posted. Where's my outro? I need to go find it. All right, with that, cheers.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at The Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, Summer.
You're right, I forgot to pickle. I'm sorry. That was on me.
I forgot. I promised a pickle. And I'm sorry. My law nerds, I have let you down. I apologize. I beg the chat's indulgence. I leave you with pickle.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at The Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.